So let's start with something that we very commonly see. This photograph in the participants, and a very common image we go through this reading. So what do you think? Can you identify any intellectual property on this page?
Google logo.
Okay. There's logo. Anything else? Yeah, Google Maps. Correct. So, okay, there's maps here. And what else do we see here? There's photo credit. Okay. There's price fixing mechanism. Yes. What about the shape of the phone? Is that intellectual property? Okay. And then what about the interface? Yes. So we have the app. We have everything that goes into the app. We have logos that are dispersed all over what you can see on your screen. And then there is the instrument. There is the phone. Phone, of course, has a brand. Phone has technology. So a simple device will have many facets of the image. So the general understanding of IP as being bucketed is something that needs to be revised. So different kinds of IP exist on a simple object that we use every day. But how do we understand what is a trademark, what is a patent, what is a copyright? So right now we've identified components, but how do we allocate slots, right? So where does a brand go? Where does the underlying tech go? Where does the interface go? So the idea is now that what we'll do is I'll try and explain the rationale behind each kind of IP, and then we can start compartmentalizing them, because that is a starting point really to understand what needs to be protected. So why it needs to be protected, of course, is you're building an asset. And once you're building an asset, it needs to be guarded such that it is not misappropriated by someone. And if this asset is going to give you edge, then of course, what are the mechanisms that you can put in place to guard it? Now, really the step one is to understand what is it that you need to protect, because without identification of that nature, it's difficult to actually start building your enforcement around that asset. So generally speaking, you would have heard of copyright, designs, patents, trademarks, and there is something called geographical indication, which may not be very relevant here, but I'll touch upon it so as to complete the picture. Now, when we think of copyright and design, we could compartmentalize them in one slot, because the rationale behind protecting them is to reward creativity of authors, of designers. So they get bracketed in one slot. Then we will talk about technology and technical innovation. They come in patents. And the third category is consumer association, where you protect what consumers come to believe or come to rely upon as indicators of quality of course. Then you have trademarks and geographical indication. Now, what exactly is copyright? Now, what copyright does is, it's an automatic protection that you get over certain kinds of works. These could be literary works. For example, you will have books, you could have essays, or it could be artistic works like a mural or a sculpture or a painting, or even a logo. So an artistic work is defined so broadly that it could even cover a logo. So all logos, as long as they are original, as in they are created by someone and not copied, they are entitled to copyright protection. So it's a very wide-ranging array of works that are covered by copyright. Now we come to designs. Now designs are aesthetic elements of usually more technical products. So to give you an example, if you see the shape of a bottle, just the shape itself, if you know the unique feature of a shape is not giving any is not a technical feature by itself, but it has some, aesthetic elements, then the aesthetic elements will get protected as a design. But if it has utility, then it will escape the realm of design and it lands in patents. Now, patents is what we protect hardcore tech. Now, when I talk about tech, the way we view tech today is, of course, changing. It's not just hardware. A lot of our technology is in software. And then we shift into the realm of what are software patents. Our software is even patentable, because what happens now is the laws have been created way back. Patent Act is from 1970. The Copyright Act is from 1957. So software is actually covered directly in the Copyright Act as opposed to the Patent Act. But because Patent Act is a legislation, we talk about software, and it talks about how not all kinds of software will get patent protection. So there is overlapping protection for tech. So most of it will be covered in patents, and a very residual portion could also go into copyright. Now comes the third category, which is consumer association. Now here the idea or the policy of the law is not to really protect the owner of the mark. Shall explain, yes, in some manner now the law does try to protect the owner, but the origins of this concept are, well, if a consumer goes to buy, say, a t-shirt, the consumer wants to be assured of some quality. And what can give them that assurance? How does the manufacturer or the seller identify it as a brand? So, for example, if I look at, say, Puma, then I recognize Puma to offer a certain standard or quality. And therefore, I'm willing to spend a certain amount of money being assured of the quality of the product. Similarly, if I have to buy something online and I say, okay, I'll buy from Amazon because my last experience was good. So here the brand is suggesting there is a certain amount of goodwill and reputation that has been garnered in the brand. So that's what the law is trying to protect. If someone tries to use Amazon or tries to copy Amazon, then consumers are going to get confused which is the real Amazon, and they may go to the copycat thinking it's the original. So it's this consumer association that the law seeks to protect. And then there's something called geographical indication. I'll just give you one example of what a GI is. GI is, it's something that is created, it originates, and is known from a specific territory. So common examples of a GI are like so different kinds of embroidery, thread work. Tirupati Laddu, for example, is a GI. So these are the three broad compartments you can put IP. But yeah, Mysore Park is a GI. So these are examples of what a GI is. Now what happens is, theoretically, we can segregate them. Practically, when you're looking at your product, your service, or your brand, you will realize that there are different overlaps between the kind of protection that you can think. But what is important is to understand what is most appropriate for you. So in some cases, for protecting a brand, trademark is going to be the only way you would want to protect it. But in certain other cases, we'll add elements of copyright to it too. And there could be many reasons. One practical example is, sometimes if you're onboarding with a third-party seller, they say, show us a registration of your brand. And your trademark applications are pending. So you'll get a copyright registration, which is a quicker process. So there are all kinds of combinations that you can play with when you're protecting your IP. Another example of overlap is software, where software can, of course, be protected as copyright. It can be protected as patent if it follows and qualifies for the requirement under the Patent Act. Or it could also be protected as a third animal, which is called a trade secret. Secret, which is another common example of a trade secret is the Google algorithm. So you could also make sure that you keep it secret and such that it doesn't get known to anybody, and then you can have perpetual rights over whatever you're keeping as a secret. And there are requirements even for trade secrets that you need to fulfill. Again, your decision on how to protect your asset is going to depend on what you're really looking out of it. Is it a short-term product? Is it something that's going to, be a flash product which you think is going to undergo lots of change in the long term, or is it something that you're going to think is going to be the bedrock of what you are looking to do with your business? So what is the asset? What you intend to do with the asset? And those kind of factors have to be taken into account when you decide you want to protect your asset. Now, another thing very important about IP is timing. And timing is crucial because it's really a race sometimes. Because as far as brands are concerned, you could think of a brand, you could start using it, but what if someone else beats you to a registration? So there is a whole nuance in trademark law, how you can get rights by virtue of use, and you don't always need a registration. Now, in that sort of a situation, yes, if you are a prior user, you will be able to stop someone who has a registration, but it's after you. But you have then got to spend a lot of money on litigation, on lawyers to sort that mess out. So a simpler solution would be first, be the first to file. Now, these are, again, timing is really important. So that's one example for brands. The other example is in patents. So when you're going to file a patent application, you have to ensure that it is not known to the world. And your own public use can make you disqualified from filing a patent application. So you have to be very careful. At what stage of the process of product development or service development are you looking to protect your IP? So again, another example. So now that we have discussed, IP can be protected or an asset can be protected in various legal forms. Let's look at this logo and just thoughts. How would you want to protect it? What would you protect it as? First question, what do you think is the IP asset here? What is the asset?
According to me, maybe it is like the idea of the company is that it sells everything that starts from A and ends to Z, and there is a smile.
Correct. So what you have identified is, okay, there's a general idea of what the company does. So there's an idea. And then there is how they have written this brand itself. How they have written it. Look at the device mark. Look at the smile or the arrow at the bottom. So these are different components. And someone messaged font. In font Sigma, yes, in situations, Disney has rights over the Disney font. So there are many assets identifiable here itself. Now, how would you protect it? You could use it. If you start using a brand, you automatically start generating rights in it. And this is called common law rights. And what basically the law tries to protect is, it tries to protect your goodwill. So when you make a sale under a brand, when Amazon makes a sale under its trademark Amazon, it generates goodwill. And when I purchase something from Amazon and I tell my colleague and I say, I really like their service, I am creating their reputation also. So there is reputation and there is goodwill that is generated in a brand, and these are assets that the law recognizes. So one way to protect a brand is to start using it. Another way to protect a brand is to file a trademark application and secure a registration. But if we are going to generate, use and reputation, then why go for a registration? Any thoughts? Why should we file a registration if we have rights in a brand just by virtue of its use? Yes, anyone can misuse the brand. That is true. They can misuse the brand if you have a registration or if you don't have a registration. But does the registration make you stronger somehow? So what happens is, a registration is a document that is recognized by the government that, look, here is someone who is now entered into the trademarks register as the owner of this brand. And rights in this brand now belong to company X. On the other hand, if you're relying on use and reputation as the basis of your rights, establishing this in court At a later point, when someone copies your brand, is going to be a tougher task. It's not impossible, of course, and we do it all the time in court, but it's a tougher ask because you will have to show so many documents, you'll have to show evidence to actually first reach step one that you have rights, as opposed to a registration, which is already a step one to show rights. So normally, as far as brands are concerned, of course, you have to use your brand, you have to make sure people know about it, and you automatically start generating rights. At the same time, to make sure that it is an enforceable right, which doesn't take you too much effort to enforce, a registration is always recommended along with your common law rights, which is generated just by use of a brand. Is there a third way in which this logo can be protected? Any thoughts? How else can it be? So let's go back. So we are now concentrating on trademarks. This logo can of course be protected as a trademark by a registration or by use. Any other way that this logo can be protected? You can see the different kinds of IP protection. Thoughts? Can it be protected as a patent? Difficult? No? Yeah. Copyright. Exactly. That's what you protect it as. And we say this is an artistic work. Artistic work is, well, anything that you think is has a little color, has a little graphic, and is original is an artistic work. So you can even protect this logo as an artistic work. Now, what parts of this logo should you protect? Should you protect the entire thing the way you see it here, or do you break it up? Now, as a rule of thumb, when you're protecting a trademark, the broadest rights are in a brand which has the least amount of restrictions. So, for example, if I file a trademark application just for the word Amazon, written, just no rights in, no any specific font, nothing. I just write the word Amazon, simply written, versus this logo that you see on the screen. Which one do you think is a broader protection or a stronger protection? The word mark application or the logo mark application? The logo. Okay, Sagar, if you don't mind unmuting yourself, could you let me know your thought process and why you think the logo is stronger?
I think the smile is more valuable. The smile part of the logo is more valuable than the word itself.
Right. And so one reason why we protect a brand is to make sure that nobody copies it, right? Tomorrow, if someone copies, say, they don't call it Amazon, they call it, say, for example, Treetop, okay? But they use, the smile, they use the other elements. Then, yes, the logo registration will help me because the whole combination is protected. But what if tomorrow someone uses not Amazon, but something that sounds like Amazon, but is not in this font, is not with this background, is not with this logo at all. So, for example, if someone uses a brand called, say, something like Tamazon, right? If someone is using a brand called Tamazon, it's not Amazon, and the logo is completely different from what Amazon uses. In that sort of a situation, because Amazon will have a word registration, it's the broadest because it has the least amount of restrictions on it. So an Amazon word registration is very powerful when you're going to go and enforce it because your rights are in the word Amazon itself, not in a word Amazon written in a specific manner with this background in this font and with this device of a smile and arrow at the bottom. So generally speaking, a word mark, a plain simple word mark gives you the broadest protection because it has the least amount of restrictions on it. As opposed to a device mark is a logo or a word mark with other elements. We call all of that a device mark. Makes your rights narrower because you keep adding elements to it. So, for example, here there's a certain font, there's a certain color, there's a certain color combination. So all of those elements combined is what your right is, as opposed to the simple word Amazon. So generally speaking, you'll have to assess what kind of rights do you want in your brand. Do you want the broadest right, or do you want to narrow it down in a certain manner because you think that the narrowed version is what is likely to be copied and not the basic brand itself. Or you will realize that someone else is already using this brand for certain goods, which may not be identical to yours, but you will not get a registration because someone else already has an application. So in that sort of a situation, you don't want to apply for a simple word because it will get blocked. So you then use the trick of adding elements, you add restrictions, you narrow your right and you say, okay, I don't want it in the broad category. Can you narrow my right? And then you apply for a trademark application. So there's a lot of thought that you need to put in when you think about protecting your brand. My recommendation on brand protection is it doesn't cost much, but you must do it. File a trademark application for your most crucial goods or your most crucial services as soon as you think you are commercially viable and you can afford a trademark application. That is very important because in the future you just don't know, you start investing in a brand, you have generated a lot of reputation in it. It's really difficult then in the future, what if someone else has better rights than you, or what if someone else has a registration? And then at the time when you file a trademark application, it increases the cost of sorting out, your asset and your rights in that asset at a later point. So it's better to do it as soon as you can. Don't do it across for all goods and services because that does add to cost. What you can do is start narrow, start with something more basic. And I'll just give you an example of what a trademark application looks like. And I said that you could, apply for certain goods, not for all goods. So if you can see my screen, the first row in the left column is trademark application number, and the second one is class. Now this class is a classification of goods and services that is followed the world over, including in India. So what the Trademark Office has done, they follow this international classification system where different goods and services are clubbed differently. So here, for example, if you come down and you look at the last column that you can see on this, last row that you can see on the screen is goods and services. And then it says class 42. So once you see class 42, it talks about certain description, providing of food and drink, temporary accommodation, etc., etc. And then right at the bottom, you'll see the last 3 lines, it says class 35. So there's a separate category of services in class 35. So there is this classification where you can file. So trademark fees, the government fee is charged according to the number of classes. So you can restrict it to 1 class, 2 classes so that you can manage your costs. But yes, my recommendation would be that you must file a trademark application as soon as you think you can commercially afford one. You must definitely file a trademark application. I'll just take you through a patent application. What does a patent application and registration look like? Now, what patents do is they protect technology, and the way the process works for patents is if I want to secure a patent, I have to make sure that whatever technology I'm claiming rights in, it's novel, which means nobody in the entire world has used that technology before I have. So it has to be novel. It has to have something called an inventive step, and it needs to have a third requirement called industrial application. If you're able to satisfy these 3 requirements, you will be granted a patent. Now, what is novel? Like I explained, it must mean that nobody else in the world is using it. And in the technical parlance, we say that all the elements of a claim are not found in a single prior art reference. So just to explain what this phrase actually means, you'll see on my screen, it says IV claim. And then there is a series of things that we call claims. Now, in the patent application, you have to define your claims, which is going to be the scope of your rights. So you explain what the invention is in these serial numbers, in these sentences, where you explain the ambit of what you're claiming rights in. So for something to be novel, all the elements of a claim, whatever I say here, should not be found in one prior art reference. A prior art reference could be a document, could be a book, could also be, someone's actual use of a technology. Excuse me. So that's general, very basic information about patent. Now, because my patent has to be new, I cannot use it commercially or in public before I file a patent application. Because my own use will make sure that my application is barred. But why so? Why do you think it exists like this? Why can't you use your own technology before you file a patent over it? Any thoughts? So what patents do is they give you a very strong protection of 20 years. Nobody can use that technology for 20 years if you have a patent over it. In return for this really powerful right, which can actually make you shut shop, you can get an injunction against someone who copies your technology, and that means they will not be able to manufacture that product. So because you're getting such a powerful right, the requirement in law is whatever you're getting rights over better be new, better be novel, better have some industrial application. So it has to be a really solid tech so that you can get this great right over it. So I've just summarized a few best practices which you must follow when you're looking to protect a brand. Always check if your brand is available, as in, is there anyone else who is using this brand? Even very large companies sometimes falter on step one, which is availability. They don't do searches, they don't check the trademark register properly, or they don't do a general Google search to see who's using it. And this mistake can cost you a lot in the long term. Second, always preserve your use documents, because what happens in brands is your first use of the brand, or when you adopted the brand, a lot turns on it. Because the first person to use is usually the person who gets protection over the subsequent user. So always preserve your use documents. Like I emphasized earlier, file applications over basic marks promptly. Whatever you think is going to be the bedrock of your business must protect that brand, maybe for just your core goods, not for everything. Don't file a broad spectrum trademark application. Narrow it down, but must file it as soon as possible. Always document all licenses, all assignments. A license is a permission to use. An assignment is an outright sale of title. If you're purchasing a brand from someone, make sure it's documented. If you're permitting someone to use it, make sure it's documented. You have to build a portfolio gradually. Always remember, you're starting narrow, but what do you want to use your brand for in the future? Keep thinking about those things so that you can keep building your portfolio gradually. A lot of companies I have worked with have used this strategy really well, where their business is actually, once the business takes off, there will be copycats. And you don't want those copycats to eat into your market share. So one way to make sure these copycats stay at bay is to ensure that your portfolio is strong enough, your IP portfolio is strong enough, you can restrain them. Prior search, like I said, availability, there's a formal procedure of searching which must be done. And please, if your business qualifies, get a startup registration under the DIPP program. It reduces your government fee by half, which is a significant drop. Now, if you're looking for best practices for tech, how do you protect your tech? First, decide how you want to protect it. Before you launch it, you want to protect it as a trade secret, do you think copyright is it, or do you want to file a patent application? All of these decisions have to be made before you launch your product, for the simple reason that you will not qualify for trade secret protection or patent protection if your product is launched. Decide what countries you want to protect your tech in if you're going down the patent route. Because the way the global patent system works is there are timelines. There are very strict non-extendable timelines on filing. If you file a patent application in India, there are restrictions within which you must file your patent applications in every country where you need protection. If you bust the deadline or the procedure, you will not be able to get your protection in other jurisdictions where you foresee your business growing. For tech, your NDAs are very critical. Who is creating this tech and how does your company own it? That chain is really, really important. So 3 and 4 are tied. Non-disclosure is critical for the reason that you don't want your invention to become public or you don't want someone to steal it. And title from who has created the invention to the company is very, very important. Your nationality of inventors also plays a role. And this is a bit of a protectionist mechanism in all jurisdictions, including in India, where Indian inventions must first be protected in India, or you need the permission of the Indian Patent Office before you can file in a foreign jurisdiction. And similar provisions exist in other countries also. So it's very important to ensure that we know the nationality of inventors and do we need these permissions or not. Again, a startup registration is recommended. It will reduce your government fee for IP protection by half. And I just have a very short, case note here, and then we can start a discussion and Q&A right after this. And I'll just explain what the facts are, and then you can let me know your thoughts. And this is one of the most common scenarios that we encounter with young companies. So there are two people who come up with a brand. So here I've just named them Aditya and Nandita. They have come up with a brand of an e-commerce business, right? And they've called it Flash. That's what we think is going to be the brand, the trademark. And Nandita, she knows this trademark lawyer who she knows from her past. So she goes to the lawyer and she says, why don't you file a trademark application for registration of this brand? A company is incorporated subsequently, and Aditya and Nandita feel they don't want to work together again, and they amicably part ways, with Aditya staying on with the company. During a round of investment a few years later, due diligence is being carried out, as is the normal course, and Aditya learns that the trademark Flash is actually registered in Nandita's name. It's not registered in Aditya's name, it's not registered in the company's name, but it is registered in Nandita's name. So the company has been using this brand, Aditya has been using this brand, but the registration stands in Nandita's name. Now, at this time, what are Aditya's options? Because the investor wants him to ensure that the company owns the brand. Any thoughts? What should Aditya do at this time? Buying it? Yes, he could offer Nandita money to just buy the brand. And what if that is actually a great outcome? And if Nandita agrees and she sells the brand, excellent, case closed. File a case. Yes, if Nandita says, no, I don't want to sell you this brand, then what does Aditya do? Offer a higher sum of money, negotiate, see what other options can he offer Nandita part of the, some further role in the company, negotiate. Yes, he could hire her. In return, she must transfer the asset. So you can think of all kinds of options that you can negotiate with. What if the negotiation does not work out? What if the negotiation fails? Then what do you do? So the company can actually file its own trademark application, and like someone just commented, you prove how the mark was adopted. You showed that both of them together adopted the mark, and Nandita is not the only owner, or she's not the owner of the mark. The mark belongs to the company. So you can file your own application, and in which you can argue all of this, and at the same time you can file a cancellation against Nandita's registration and make the two proceedings work together, and hopefully that should lead to a result. What if Nandita starts a competing business under the brand? Then you need to file a lawsuit to restrain her from using the brand. But she already has a registration. So the underlying idea here is when we adopt or when we create IP, at that time, it comes together as sometimes as friends, sometimes as colleagues, but we are not quite sure of who owns it, but we are sure of, we want the company to own it. So my recommendation is whenever you have an asset, it's an asset for the long term, and you intend to incorporate a company who should own that asset, make sure the company owns the asset. Oftentimes we see promoters or founders who leave the company to carry the asset with them without really talking about it, because the discussion is, do we have a registration over this brand? Yes. That's where the discussion ends. Nobody's thinking about in whose name is the registration. It's not in the company's name. If it's not in the company's name, it won't be counted as the company's asset. It's not a partnership where you can take the partner's asset and say it's the partnership firm's asset. It's an incorporated entity, and a director's asset is not, or a shareholder's asset is not the company's asset. So the general message here is, make sure your paperwork on ownership of your IP is complete, and don't postpone this discussion to a later time, because cleaning up the mess then is not easy sometimes, and also becomes expensive. So that's my presentation. If you guys have any questions, anything, feel free to ask.
So I have some questions from the registration, so I can ask those now. And in the meantime, if you guys have any questions, just post them on the chat. So first one is, how do you get IP rights for technology without having any infringement issues later on?
So like I said, to get IP rights in technology, first you need to identify how do you want to protect it. And at the same time, if depending on how you want to protect it, you have to do a search to check what is already in existence. So for example, if you want to protect tech as, say, a patent, then we have something called prior art searches, where we search the database of the Indian Patent Office and several other jurisdictions to identify what technology is already protected, because anything that is already protected or disclosed is going to hit you, and therefore there's no freedom to operate. So similarly, if you're going to, again, it's rare, but if someone does want to file a copyright application over a software, that is possible. But again, you don't really need a prior art search for a copyright application, because the threshold of protection is lower. But if you are going to protect your patent, tech using a patent, a prior art search is definitely a must. Of course, to know whether you have freedom to operate. Second, to ensure your costs are well spent. It shouldn't happen, because patent prosecution, patent filing to grant is a long process and expensive one at that. You don't want that investment to go down the drain at the later point when you realize either your patent will get rejected, or you feel that there is a third party who has better rights in the patented technology already.
Awesome. So this one, we might digress a little in the question, but on which basis can shares be distributed in a startup without any disputes in the company?
Okay, so when you're talking about share distribution, you need to, of course, identify who the shareholders are going to be, and decide what kind of rights will flow to each shareholder. The cleanest way to do it is to draw up a shareholding agreement, which you need to do in conjunction with both a lawyer and a chartered accountant or a company secretary. Draw up a cap table and make sure you document it in a shareholding agreement, because that will define of course, the proportion along with what rights are being given to each shareholder, so that in the future there's any disagreement or any dispute, then you can, of course, go back to this written document which is signed by everyone to resolve the dispute. And as you keep adding shareholders in the future, everyone keeps getting added to the same document, so that everyone is literally on the same page about their rights. Biggest disputes happen when we don't document our discussions and we don't document these divisions.
All right. Next is, can you register an idea as intellectual property?
No, you cannot register an idea. What you can do is register manifestations of that idea. So again, see, the way law works is that it gives us these definitions on, well, idea by itself is not protectable, but certain developments of that idea are protectable. So for example, if I make a concept note, I can protect that concept note as a copyright, because I can argue that it's sufficiently developed for copyright protection. But I probably can't protect a concept note for tech as a patent, because I need to show a workable invention. So just a thought cannot be protected for the simple reason that if we protected everyone's thoughts, then how will we think? So it has to be a development of that thought, and different stages of development of that thought can be protected in different ways by different IPs.
Got it. All right. Can you give an example or average time frame and expense in registration and resolution of IP issues?
So this depends on who your lawyer is. To a large extent, there are all kinds of budgets that you'll see for IP dispute resolution. What you need to first understand is, how do you want to resolve a dispute? Do you want to litigate? That's one option. Do you want to mediate? That's another option. Or do you want to do something like, send a legal notice as step one? So all three options have different timelines. They have different fees that are charged by the government and also by the lawyers. So you first need to get advice on which is the most appropriate way for you to resolve a dispute. One mechanism that has been working a lot of late is something called pre-litigation mediation. You don't have to file a suit directly. You invite the other party to mediate with you in a very formal setting before a mediator of a high court or a district court, and you try and resolve the dispute. And more often than not, disputes where you are very strong on merits, you're able to resolve them during pre-litigation mediation. It's a more cost-effective way of sorting out disputes which are easily resolvable. So again, to generally say how long it will take or how much will it cost is not going to be easy. It will depend on how you want to sort it out and which lawyer you're going to go to sort it out, because there is a whole range of fees. And which court you go to, even jurisdiction will matter, because the court fees of each jurisdiction is going to be different.
All right. Next is, what is the intellectual property of domain names? If I own a domain name, does that have any effect on any other IP that I might have?
Great question. So use of a mark as a domain name means trademark use, but domain name registration does not give you any separate intellectual property rights really. It actually becomes more like evidence of your trademark use. So tomorrow, if I want to file a trademark application and I want to tell the registry that I've been using it since a certain year, I can rely on the domain name that I registered in the website that I created using that domain name, or I'm hosting on that domain name. So it becomes a document to show use as a brand. But it's not a separate IP right.
Got it. Okay. How do you protect your IP while working with manufacturers overseas?
With manufacturers, again, depends on nature of IP. If, for example, it's tech, please, you need to have your non-disclosures in place, depending on what kind of tech you're protecting. Now, in addition to, of course, patentable subject matter, there are lots of tricks of the trade that you have. For example, you will always know that, okay, to package my product the best, this is how you should do it, because this is the most cost-effective manner for me. And that's a little secret you'll tell your manufacturer for you. So make sure you have NDAs in place, non-disclosure agreements, to protect this kind of information also. The second asset that you really need to protect besides the tech and your trade secret know-how based IP is also your brand. You always want to have control over it. Always make sure that your engagement with the manufacturer is documented, and you list down how they can use your IP, what they can use, how they should use it, what they should not use, should all be captured.
All right, cool. So I'm just going to the questions in the chat. So one of them is, how can we protect a different technology with the same technical stack but a different approach?
Okay, so it depends completely on how you draft your claim. If it's the same underlying tech but just a different use of it, a different use will not get protection. But if you're saying different approach, I'm not sure what that means. Does it mean it's a different way of achieving the same result? It will depend on how different it is really. Because patent rights could also extend to, of course, what you claim, and what is the same way to achieve the same, a different way to achieve substantially the same result. So we have to study the claim language on how we can structure it so that it's different from what already exists. This may not be, it's not the simplest thing to do, but again, fact by fact, we can assess, will what you are claiming rights over be protectable over what you think is already in existence. So I'll give you an example. For example, communication, telecom. So you will have competing approaches to achieve the same result. For example, if voice quality is something that three technologies try to address, the end result is great voice technology or voice technology of a certain grade, but there are three different approaches. So if they're drastically different and they have different underlying principles, of course they will get protected. Just because you have the same objective, that's no bar. But if one is just a slight work around the first one, may not be protectable.
Got it. There's one. Okay, quick. If you could quickly highlight the difference between copyright and trademark.
Right. So, like I explained at the beginning, a trademark is something that you get protection over because consumers start associating that brand with you. Right. So it could be a logo, it could be a word, it could even be a shape. There are different types of trademarks. So the general idea is you have your goodwill, you sell products, so you sell services under that brand, and therefore you should be entitled to protection over it. A trademark gets protection if you seek a registration. It can be perpetual, as in you have to renew it every 10 years. But if you keep renewing it, the protection is perpetual. And the whole idea is to protect your goodwill and reputation attached to a certain brand or a mark. Copyright, on the other hand, is to protect artistic work or creative work, solitary work like a book or a montage, a video, a sculpture. So they are protected generally as copyright. The overlap with brand and copyright is basically a logo which can also qualify as an artistic work. So to that extent, a logo can be protected both as a trademark and as a copyright. When you talk about a copyright protection over a logo, the duration of protection is limited. It's lifetime of the author of the work plus 60 years after that, whereas trademark is perpetual. Again, for copyright, you have to understand there's a difference in concept of who is the author versus who is the owner. If your employee creates it or you hire an ad design agency to create your logo, do you own copyright in it? Who owns copyright in it? Again, you have to document these things to make sure that you become the owner of copyright in the logo. Because unlike a trademark, copyright will need someone to own it. Just by using the copyright, you don't get rights in it like a trademark.
All right. So the next one from Shashwat. Okay, basically he's saying that he doesn't want to get into he doesn't want to bear the cost right now of incorporating a company and doing the registration and all that. Is there any way that he can still protect his whatever he's offering in the app, maybe UI or whatever assets there? Can he protect it in the terms of service in the app itself?
Yes. So what you can do at this stage is, break it down. What kinds of IP do you think you have? And then you can follow different strategies for different IPs. So, for example, if there's a brand, the brand can be protected by, making it distinct from other elements. Using it in a certain manner, and you can write PM next to it. Do not write R next to a brand if it's not registered, because that's a criminal offense. You can't do that. But you can write PM, which means trademark. That is fine to you. So you can start identifying. Now, different elements of an app could also qualify for copyright protection. Now, with copyright, the thing is, there is automatic copyright in India. If you create something original, you get copyright in it. If you create an original literary work, artistic work, you automatically have copyright. But the author has copyright, the person who creates it. So you can use a copyright legend if you think a certain portion does qualify for copyright protection. You can use a copyright legend to mark it and say, look, I have copyright protection, and then you write the year or the date of creation, because that is when you plant your flag and say, okay, this is the date when this was created. Again, like I've been emphasizing, each product of yours or each service of yours will have several different kinds of IP. So, you can't have one blanket approach for protecting the entire product. You have to first identify what component will be protectable and in what manner it can be protected. But you can, pre-registration, also take some steps to start marking your IP.
Oh, got it. So the two questions on how do you go about doing prior art search?
So you do a prior art search. What we normally do is we have patent agents who do this prior art search. One way to do it for free of cost, if you want to do it at your end, is look up Google Patents and see what you can find there, or you can go to the Indian Patent Office website, and then there are ways of searching prior published and granted patent applications. But it's not very easy because you can't put too many words there to really search. Even the abstract, you can just put a little bit and the searches will be really bulky because it's a very small search criteria. It's a very broad search criteria that you can use there. But Google Patents is one way to do it. Otherwise, you get in touch with a patent agent who will do it. But of course, again, patent agents will have different fees and you have to work with someone who works for you.
All right. For companies that change their logos, if you want to change your logo, do you have to go through the entire process again?
It depends on how drastic the change is. If it's just slightly different, I would say let it be. But if it's something completely different, then yes.
Okay. Again, similar to the domain name, if you have an app on the Play Store, does this contribute to your case in terms of owning the intellectual property?
Yes. Again, like a domain name, app on a Play Store will show you use, and use attached to a certain date. So that's important. Another thing an app on a Play Store will also help you with is how many people are using it. It can actually show your goodwill and your reputation, the number of downloads, for example.
If one needs to have right over the name and logo that I'm using for years without registration, what should he do to get the rights, copyright or trademark?
If it's a logo, I would recommend both. And the reason why I recommend both is, yes, trademark is not very expensive to get, but a copyright is even cheaper. So I would recommend get both. But as far as brands are concerned, your primary protection must always be trademark. Copyright is something you can supplement. So if you have to choose between the two, pick trademark. But if you can do both, then both.
All right. One last question. What part of software is protected? I have heard that algorithms are not protected.
Oh, this is a session by itself. What part of software can be protected? So again, well, most of law is gray, and this is definitely something that is gray. What software can be protected is anything that has a technical effect. A mere algorithm, according to our Patents Act, cannot be protected, but then one could argue everything is an algorithm. What is an algorithm? It's a way of doing, it's a set of instructions to do certain, something in a certain manner. So by that logic, nothing should be protectable. But this is not what courts have held. What the law is that any technical effect, a software having technical effect is protectable. And to give an example, if you see a software patent over, like I said, voice improvement over telecom, that is protectable because it has a technical effect of improving voice quality, as opposed to software which gives you more colors in MS Word. That may not qualify because they say changing colors in MS Word is not technical effect. This is gray, but as tech is moving more and more into software, I think our patent offices and courts are also realizing that this is how that really needs to be protected.
Okay. To close, do you know what the rates would be for a copyright or a trademark?
So there are two components. One is the government fee, and the other one is a trademark lawyer fee or a copyright lawyer fee. The government fee, if you are an individual or if you are a startup, is for trademarks is 4,500 per mark per class. For copyright, it's about 5,000, I think, for 2,500 for each work that you want to protect. But if the lawyer fee, of course, is a whole spectrum. In our profession, you'll find a lawyer you'll find a website that does it for you, or you'll find a lawyer, who charges maybe 5 times that amount. But it's completely up to you what advice you're looking for. What I have seen is a lot of people pick the cheapest option.
Usually people say, okay, the cheapest option is the best, but always remember, you must, when you're thinking of protecting IP, think of the strategy, who's giving you strategic advice, what are the incentives of that person, do you trust that lawyer? Those kind of factors have to go in when you pick your lawyer. Cheap is not always best, is what I would say. But again, you will get a whole range of lawyers.
Thank you so much, Abhilasha. We really appreciate this.
Thank you. This was fun. Thanks a lot.
Thank you so much. Thanks, everyone.